Edward, Barry, thank you very much, both of you, for joining me today. Yeah, it's been quite a whirlwind couple of weeks, I would say. Certainly, well, I don't know from your perspective, but certainly from my perspective, keeping up with everything that's being said on LinkedIn since we posted about the Get On Board and the HMRC case. Yeah, obviously keen to just get your guys' thoughts on that, and try and establish basically, yeah, obviously how you guys have seen it since things have come out. Obviously, it's Edward. I know it's gained quite widespread interests, and the case has received quite a lot of support. So I was just keen to get your understanding on how do you feel about everything.
Yeah, it's been interesting. I mean, obviously, I've had various people contact me via LinkedIn on the case, and some of them are kind of looking for advice on their cases. So I'll send those to Barry since I'm not a professional advisor. Some of them just saying thank you, and I think Barry's received those kind of thanks as well. That there was no real precedent, and somebody needed to take this to tribunal and test the HMRC position. So, yeah, I mean, it had to be done. I don't really feel like great about the fact that I was the guy who had to do it, but you know, it is what it is, and it had to be done, and we took a view that, you know, you had to go and test the HMRC position and show that it was completely without merit, which thankfully the judge agreed with our view.
And how about you, Barry? How have you felt about the interest and support around the case?
Yeah, I think this is great, superb news for the software industry and also other high-tech industries as well. I mean, everybody involved in making R&D tax claims should get behind this. The situation was, in my opinion, HM Revenue Customs have pretty much created this pressure cooker. And I think that's been brewing for a couple of years in actual fact. And now we've actually released a little bit of steam, I think. Wasn't great. We've pushed back. And what I will say is enough is enough. You know, that was what we got to on this, Edward, didn't we? Said enough was enough. Please stop rejecting genuine claims from startup high-tech software developers. You know, it's completely in contrast to the government's initiative to support AI industry and other areas of software development. And what I would say, what is the experience behind this, and it has been for the last 2 years, is the R&D compliance officers have little or zero domain expertise. It's also, I think, wrong that we can't speak to a compliance officer or even their internal appointed competent professional, which was this case, the CIOT team. They send out templated letters of experience, which actually got the wrong company's name on, certainly sometimes the wrong project name on there. And what I would say, and don't get me wrong, I think there's been a huge amount of spurious claims and fraud, and they need to absolutely clamp down on that. But they've created this position themselves because 50% of the claims, you know, they were not even looked at. I mean, didn't even have one word behind them. And suddenly this all get kicked off 2 years. So absolutely, fraud, spurious claims but they've gone literally to the opposite end of the spectrum. And they actually are stopping genuine. And they're actually starving UK high-tech companies of much needed cash. That's my opinion.
Yeah. If we look at the sort of initial reaction around, or sort of initial reaction from your guys' perspective to the rejection of the case by HMRC and obviously the subsequent tribunal win, Edward, just from your perspective, what made you take this case to the tribunal, given that there was no real precedent for success in these cases for the most part?
I think during the process, and I actually think the judge quickly realized that when we sat in front of him, this was a hill I was willing to die on. And I don't understand how anybody who had kind of modicum of common sense at the HMRC side was willing to go this far. I mean, I actually thought even in the tribunal, within 5 minutes of putting our case forward, that their counsel would just say, actually, guys, we got this completely wrong. We should stop now, and offer to settle. I couldn't believe they continued to argue. They had really no basis for their argument. So it doesn't massively personally benefit me, but it was absolutely wrong, completely and utterly wrong. And this was taken on a point of principle to show that the HMRC position was completely without merit. And I'm glad we were able to do that. And hopefully it helps other software companies going forward. Because, you know, in the tribunal, it showed they didn't understand their software. They didn't understand how software worked. After half an hour, the judge completely understood what we were trying to do, how we were trying to do it. And yet the HMRC side just demonstrated their incompetence at every turn.
And Barry, from your side, obviously just describe your journey from making the R&D tax claim to obviously what led you to fight the case on behalf of Get On Board.
Yeah, I mean, well, this was a journey and a half. And it's like roughly 3 years ago. I looked at my notes. We actually submitted the R&D claim and a detailed technical report back in March 2021. It was selected for compliance check in May 21. We answered all the questions. We provided additional evidence, all about the baseline technology and where this was an advancement in capability and knowledge. And then the compliance officer literally provided us, and this is what I'm seeing throughout, a couple of lines. I remember actually receiving a letter back which basically copied and pasted our response and said existed. I mean, the potentially just doing a Google search. So that then went to, we've obviously appealed. We actually appealed to the solicitor's office and the legal services, which is basically solicitors who are meant to internally review, in theory, be independent. I'll come on to that probably a bit later, but I think it was anything but. They literally copied and pasted. And they upheld that decision November 22. I remember that we were the first tribunal case for the Judge Baldwin, in that was this year, in Jan 2024. And then we got a decision in our favour, and that was in July 24. So yeah, I mean, there was a huge amount of evidence that was provided, huge amount of detail. And we were told to simplify as much as possible. But even so, it was clear that there was some kind of direction just to say no, which isn't that real time. And yeah, but yeah, 3 years.
Yeah. And one of the things I took away from the case notes itself was the suggestion that the proceedings themselves could have been more straightforward or even avoided if both sides, and I think to use the terms in the document, were put their scientific cards face up on the table. What are your thoughts on that? And do you think possibly there was an opportunity for, is that an opportunity that was missed looking back on it now? Or what would you say to those comments?
Can I answer that one, Kit? Can I answer that one, Kel? Because I actually saw a post on LinkedIn. I didn't jump on it because it was a senior partner at a large accountancy firm who made this statement and completely misunderstood what the judge was getting at. We obviously, as any applicant, have to submit quite a lot of detail. I mean, an R&D tax claim is not a small amount of work. Hence why I would recommend any company has to use an advisor to do this. And thereafter, I and Barrie and the team put a lot of work into multiple resubmissions, if you like, and clarifications. We could not have written any more than we wrote. I mean, this is a lot of detail that was given. what the judge is highlighting is on the HMRC side, the response was largely, no, we don't think so. No, this is not R&D. And the judge took quite a bit of time at the tribunal to go, could you please clarify why you're saying no? And really, HMRC had no response to that question. They couldn't really answer the question. Why are you saying no? They went, oh, maybe this, maybe that. Their counsel started throwing mud at the problem, see if any of it would stick. But really, the answer was, we just don't think it's R&D. It's just not R&D in our minds. And I don't understand how you can have that position without domain expertise. So I think it's very important for everybody to understand what the judge was saying. The judge was saying that basically HMRC can't just sit there and say no. If they're going to say no, they have to have some kind of rational reason that they could stand before a tribunal and defend. And they did not. And that's really the subtext of what he was saying in my mind.
Barrie, did you have any comments on that as well?
Absolutely agree with what Edward is saying here. What we tend to find is that we obviously have competent professionals. We do a huge amount of work to ensure that the project does qualify. Unfortunately, the opposite to a competent professional, which we have at HMRC in Customs, I'm not going to say the word, I don't want to. I mean, the chap himself, the compliance officer, was put in a really, really difficult position. You know, first software claim, no software experience. We weren't allowed to speak to their internal experts. We requested it twice. All I say is, come on, let's talk to people. Let's have that discussion. You know, I asked what the domain expertise was of the person in their CIOT, the Information Commissioner's Office, and there was no evidence from them whatsoever. So, you know, I think some of the paperwork we sent through, it was sent through from the compliance officer to the SOLS team. There was a fundamental response that we provided that didn't even acknowledge. So, yeah, I think in terms of legal formalities of the case as well, I think smoke and mirrors was put forward in an attempt to delay the proceedings, and that's what it would amount to. And the liquidators had appointed Edward and Myriad verbally, wasn't in writing, it was verbally. I think you may have an email, but all they were trying to do was delay, hoping that we would go away, or the liquidators say no. But as Edward said, we had no financial gain in this whatsoever, and therefore to us it was, you know, we're representing the wider software community, and that was important. That was very, very important. You know, particularly if you look at the government's initiative in boosting innovation, particularly with AI, which this project was at the time at the forefront of. So yeah, no, absolutely.
Yeah.
If I can pick up on that point as well, Barrie, I saw a LinkedIn post on this point as well, which was somebody was saying, you know, the caseworker at HMRC should be, you know, reprimanded if not fired. And again, I didn't respond, but I think that's wrong. I mean, I think, as you said, he was put in a very difficult position. He wasn't trained. He wasn't a domain expert. He'd never handled a case like this before. I mean, I'm sure he's a nice person, but unfortunately, we were put in the position at a tribunal, and I think he probably took it quite personally, that I had no choice but to go, you are completely incompetent. I am utterly competent. You are completely incompetent. And, you know, we didn't want to do that because, again, I think this was a structural problem and not a personal problem, but we had to do that. And he was. I mean, he had no expertise, and I really felt he was let down by HMRC to be even. I don't know how he was allowed to turn up at that tribunal on his own like that, because, you know, his position was indefensible. But if it was a one-off caseworker who had gone rogue and done this, I'd say okay, well, it won't happen again. The worry is the structural problems that cause this will not be fixed, right? So if you've got untrained people with no domain expertise just saying, no, we don't like this claim, I mean, that's not the basis of it can't be the basis of testing whether a claim is valid or not. And I agree with what Barry said up front. Of course, I'm in the anti-fraud space. That's what I do, right? So I am 100% against stopping fraud. I actually create tech to do that, and I believe my tech could do a better job than HMRC caseworkers because I actually know what to look for. It's pretty easy to create filtering tech which would separate out a completely spurious claim from one that's potentially valid. I'm not saying you wouldn't and shouldn't keep a core team of experts who can look at things. But to me, the value of this caseworker was negative. There is no point in having a caseworker as untrained and is as, inexperienced as this guy was looking at reviewing claims. It's pointless.
Yeah, it seems like from an outsider's perspective, it seems like this guy, like you say, was put in a very sort of difficult position. I mean, Barry, obviously, a lot has been said about the scheme in the last sort of 2 to 3 years. Actually picked up on Sunday, I think it was, The Guardian sort of wrote an article. Looks like they were kind of rehashing a lot of what was said sort of a couple of years ago about the scheme and the fraudulent claims and stuff like that. Do you feel like this is coming sort of because of this sort of the publicity that R&D tax credits has got in the last few years, a lot of it being kind of negative? Do you think that's what's putting HMRC in this position to kind of direct people with very little experience to kind of say, look, if you're a little bit unsure, then just say no? Or what do you think? Do you think that's leading to them being a lot more strict?
Well, I think HMRC Customs, unfortunately, allowed this to happen. They took away the regional R&D units. We could actually speak to an inspector, have a sensible conversation with them, and answer the questions, and they will speak to the competent professional. You had that arrangement. That worked very well. They took all that away. Obviously, a couple of years ago, it hit hard and fraud was identified. Spurious claims, and they did a sample check of 500, and the outcome of that, according to HMRC Customs, that 50% of claims shouldn't really be made or should be reduced in value. However, what I would say is, I know for a fact that 50% of claims did not have a word behind them. They just submitted the tax return.
Okay, so no technical reports.
No technical report whatsoever. 50% of the claims did have a technical report, but they didn't have the resources to look into them. So you had a very small amount of claims that were being looked at. And I do remember an inspector saying to me, they have 3 piles. They have one pile from R&D tax advisors that were doing a great job on their behalf because they were sifting through. They had another pile from what they would call questionable R&D tax advisors. And unfortunately, by not correctly policing the system, that's what HMRC Customs are there for. To police the system, but also the government has levers very quickly to change the scheme in terms of its value, and i.e. through the tax system. So it had very little policing. They anybody that's making a claim for the first time, they may look into that. And then what they've done is the absolute opposite. They've just recruited. They've gone from 100 to over 500, and they've just recruited literally people, bum on seats. That's what they've done. They do not have the competence to look at claims. And they're kind of like doing corrective action, but absolutely gone too far with it. They haven't got the skill set to deal with this. And that's the issue here. That is the issue here. And I think we'll see some balance coming through, but the balance will only happen when they actually realise that they need to review these claims with people that have domain expertise, whether that's within HMRC Customs or they go elsewhere to a professional body, for example, for each industry sector. That's the way to do it, and that's what they need to achieve.
And just going back to the case, Edward, I suppose the question for you is why why did you appoint Barrie to represent you at the tribunal as opposed to a solicitor or a barrister?
Actually, that's a very good question, and actually a question I've answered on LinkedIn to a few people who kind of found themselves in similar situations. And I think it's important for companies to understand what happens at tribunal, because you as a company you're not used to going to a tribunal, certainly on not on a matter like this. So I have a lot of experience dealing with lawyers over the years. So I kind of like lawyers, but lawyers do certain things. So there was no precedent here. So it was quickly discovered that there was no precedent. So you couldn't really appoint a barrister and they're going to say case law at this point helps you, right? So that kind of knowledge, of that legal library knowledge, doesn't exist because there's no precedent. And then when you look at how the tribunal plays out and what you're trying to prove, this was really showing that we were competent and we had R&D. It wasn't a legal argument. And that's why Barrie was the right person, because what he could do was, look, in my knowledge of other claims and my knowledge of how this works, this is what I can tell you. And I also think that, the kind of semi-legal part, again, Barrie was better at position to do than a lawyer, which was, let's return to the BEIS guidelines. So we were very much, okay, we're going to tell our story, and our story is completely, there's no holes in our story. But at the same time, we are going to demonstrate to you that our whole claim was based on the wording of the guidelines. We know the wording, we know it backwards, and we adhered to it. So again, a barrister could say that, but it's not the same as, it doesn't have the same weight as Barrie saying it. So I really think you're not in a court of law with this massive case library behind you. You're in a tribunal and you're trying to demonstrate competence. And I think, luckily for everybody else out there, we were a very good team at doing this, because it was a competence thing we were trying to demonstrate, and not a knowledge of the law, right? And given there was no precedent, that wasn't the important bit anyway. And I think we succeeded in that. And I also have advised some other companies that, first of all, every company who's being questioned should read the judgment, right? Because it really will help you. The judge gave a lot of useful points and really thought about this case very carefully. But I think some companies will need to send two people into the tribunal from their side. They will need to send one person who can answer high level, this is what we're trying to do, this is, context of what the company is doing and why it's trying to do it. And in a software sense, they may need to send a technical person as well. Luckily, in our case, I do both. So I can talk at a high level and I can talk code because I write code. But in other companies, they may not be able to do that. So I think other companies will require two people to do what we were doing. And of course, you need somebody to perform the Barrie function, and maybe a domain expert barrister or solicitor could do it. But I think it's hard. I think it's much easier for somebody who knows these claims, has made these claims, and really gets what we're trying to do, right? I mean, it's also knowing what we were doing and why we were trying to do it helps, right? Knowing that in 1979 there was a case X that said that's not really how you win this case.
Yeah. Barrie, did you have any, I know you mentioned the legal formalities already, but did you have any comments on what Edward just said?
Yeah, I think Edward's right in that this is all about somebody with competence describing the project and also knowing what the current state of art was, the baseline position. the beginning of the project. And of course, there's over 3 years, there's huge rapid development, particularly in AI, as we all know. And I think the role that we had to play in this is one that we had somebody that had worked within the industry sector, was a software project manager for Experian. And that helps because we therefore understand the arguments and the tech. Therefore, we're able to support the information that Edward provided and also add an extra layer. And that extra layer is actually the BEIS guidelines, which is under the tax legislation for R&Ds, what HMRC and customs have to look at and reference. And there's particular ones I'll talk about. So you've got paragraph 6 and 23. So 6 talks about advancement in science and technology overall within the field, but it also talks about knowledge and capability. And that's something very important. You're creating additional, advanced, additional or appreciable advancement in terms of knowledge and capability. And that is key because you use code. You can look at code. We're not, in this case, not reinventing code. We were taking building blocks of existing software, and we were taking those as a foundation and building upon those, and that's where that comes into it as well. And the other thing to say here is, and it's quite clear in the BIS, is that even if this particular solution exists, so somebody else has developed it, you cannot get your hands. It's not readily available because it's in public domain or it's a trade secret or whatever. And that still means you can make a claim. So you can do, you might say, okay, someone's got a solution, which will be slightly different to what you're trying to achieve, or it could be a different use case, but that's still allowed. And I think HMRC and customs need to appreciate that a little bit more, rather than just look at Google and say, oh, that product exists, that piece of software exists. We know someone's already doing that, but if you can't get your hands on that knowledge, that IP is, which, a lot of people don't actually, what their AI models are all about, etc. And that's absolutely fine. So I would, absolutely say that I think that HMRC and customs really need to focus on what I would call spurious and fraudulent cases. That's where the attention needs to be.
And Edward, what would you say is your sort of key takeaway from this in this sort of tribunal win?
Well, there's a couple of takeaways. At a legal, from a purely legalistic sense, I think the key part of the judgment was where Judge Baldwin, kind of said there's a shifting of the burden of proof in that HMRC just can't say no with no basis and then say it's the burden is on the taxpayer to prove their case, and no matter what you say, they go, well, sorry, in our minds you didn't. So basically the judge says that's not a defensible position. So I think that was the key legal point. There were loads of really useful points away from that. I think my other point would be a hope rather than anything else, which is I think somebody senior at HMRC needs to say, look, if we're going to pay out on software claims, which I think is where we are, right? The government could change their mind. I hope they don't, because I think it would be a terrible thing for the UK if they did, but they're entitled to decide to do that. So if they're going to pay out in software claims, somebody at the top needs to say, look, as Barrie said, there may be fraudulent claims. And I say fraudulent in the sense of, completely made up, or, people pushing it, right? They're changing a website and, they're, changing the color of your landing page or whatever, right? So clearly there knows. But somebody at the top needs to say, look, guys, we're trying to support R&D. The purpose of this scheme is to help people doing R&D. So we should be saying yes at the margin if it looks like R&D, and they should be sending down guidelines to the team going, look, this is R&D and this isn't R&D. It should be. It's not that difficult. If you're in this domain, it's very easy to know the difference between somebody who's just making it up and really has no skills to invent anything, and somebody who's trying to do something inventive. And if I looked at somebody's GitHub repository for 5 minutes, I would tell you the difference. I mean, it's not a very complicated thing to figure out. And as Barrie said, right, it's a really stupid position to say, oh, well, somebody somewhere in the world is vaguely doing something similar to you, because probably there's somebody somewhere in the world doing something similar to almost everybody. I mean, how much utter novelty will there be in the world? That isn't what R&D is. I think the judge really liked getting into the detail of where AI is and where we are right now. So, is Anthropic doing the same thing as Mistral, as Google, as OpenAI? Yes. Are they all doing massive amounts of R&D? Yes. I mean, it's very simple when you start making it concrete and go, they're all doing large language models, but they're all doing incredible work and creating new stuff. And to suggest they're not doing R&D because one of them did it first is complete nonsense.
And Barrie, same question to you. What do you think is what do you consider as the key takeaway from the tribunal win?
I actually share the same thing here with Edward. I mean, the shifting of the evidential burden is a significant game changer, in my opinion. I recall seeing in the letter and other letters, we actually have another one going to tribunal, not software related, which once again is a complete slam dunk. And I'm hopefully really pleased when I just realise that, because it's just worth anybody's time. But anyway, I remember in those where it says that, the evidence, burden of proof has to be on the claimant. But when when the judge says that enough's enough, this is there's so much you can put forward, blah 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 blah. And all we want from HMRC and Customs is you're saying it's routine, advancing the only and it's company that is actually benefiting from this, so it's development for the company. Yes, it's highly clever, but it's not. They've got to give proper evidence. Absolutely got to give proper evidence. And I think that is a game changer. I really do think that's a game changer. I hope that HMRC and Customs take this on board. And as I've said before, they really, really need to focus on using professional bodies that have domain experts in various industries. It's got to be done that way, because at the moment you've got people that are basically examining claims, and have got no qualification whatsoever. Imagine, you've got someone taking a bloody maths paper, and when you've got someone who's got no clue on maths, for example, and they're trying to do an A-level maths. It's just ridiculous, absolutely ridiculous. But yeah, so yeah, definitely the shifting of the evidential burden that Judge Baldwin put into that. I think that is a game changer for sure.
Cool. And Barrie, for companies currently sort of dealing with an HMRC R&D tax inquiry, what would your advice be to them on sort of managing that and addressing if you were to address any of their concerns about undergoing this process?
Yeah, absolutely. Number one is do not give up. I know, and Edward, we were very frustrated during that journey with the level of incompetence and the pushback for no apparent reason, or very little reason. I said little reason was given, but do not give up. Yes, it took us 3 years. And we were given a compliance officer, we're given their name. We can speak to them, but now, generally speaking, you don't get that. Your claim is reviewed by somebody from the R&D tax compliance team. So when you put your response in, somebody else will pick it up. We've not read the previous one, which is an absolute, it's just chaos. It's just chaos. So do not give up. You've got a couple of what I call internal appeal processes. You've got alternative dispute resolution, I believe it's called. And one that we did was the Solicitor's Office and Legal Services Sold, which once again meant to be impartial. In my opinion, my experience says that's not the case. I believe that information has not been passed from the compliance officer to the Souls team. And when you've got solicitors, their natural behaviour is to defend. They can go to internal professionals, but their natural behaviour is to defend. And I think it has to be, HMRC and Customs, to prevent a huge increase in, this is what's going to happen, tribunal cases. Really tie themselves in, like, they've got to go, as I said, to professional bodies, or they've got to appoint independent panel, each industry sector and each field of science and technology. That's what they have to do. And until they do that, we're going to end up with the hard, almost like teaser-like policing that we have at the moment to the very little policing. We're going to go between the two, and it's not a solution in that. But yeah, so what I'm saying is, don't get concerned about the Souls, the ADR. Definitely reference the case that gets on board, particularly about the burden of proof, and take it to tribunal. It's and yes, you can, if you are confident in your technology and the advancement or the appreciable improvements being made, go to tribunal. It's done on Teams. You will find that they are understanding of people that are not from the legal world. I've got to say that the Judge Baldwin was very accommodating during it on both sides, because they're there to get a resolution. But yeah, I would say, just, if you've got confidence that your project qualifies, push forward, absolutely push forward. It's the only way that we're going to get this change through.
Absolutely, yeah. No, echoing Barry's points there, I think it was a very stressful and a very long process, but the tribunal itself was the least stressful part, because you were just allowed to make your case in front of a third party who was trying to be objective. So what Barry's saying is correct. How can HMRC be opining on any of these kind of legitimate claims without leveraging industry expertise? I was kind of shocked. I don't know if you were, Barry, that
completely.
That the caseworker, he had only ever worked in one software claim, which was this one, was still till the end adamant it wasn't R&D, was didn't back down. But interestingly, he said, well, most of the claims I work on are in construction. And of course, I'm a software guy, so I immediately went, construction? How do you do R&D in construction? How would there be loads of... But I'm not an expert in construction. I'm not going to opine on that. I mean, obviously there is a way, and people can do R&D in construction. It just strikes me as weird, but that's because I don't know that domain. Likewise, it seems to me that I could probably concoct a medical science, pseudo-medical science claim that you could give to that caseworker and he would approve it, because he'd kind of think it sounded scientific and he didn't really know anything about it. I mean, how does anybody opine on the R&D in these domains, especially when R&D is more and more complex? As each year goes by, each branch of human knowledge becomes more complex and your ability to know that domain diminishes. So you just have to bring in experts and say, look, if we're talking about construction, get somebody who's in construction. If we're talking about medical, get somebody in medical. If we're talking about software, get somebody in. It can't work any other way. It's insane to create a position where you're asking some generalist, untrained person to opine on all these potentially different domains.
And what advice would you give, Edward, to companies that are concerned about making an R&D tax claim? Obviously, there's, I've seen comments on LinkedIn, people saying it's more hassle than it's worth, and, comments like that. I mean, what do you say to companies who are concerned about making an R&D tax claim and are put off due to those potential pitfalls?
I think, unfortunately, there's a lack of understanding of the startup ecosystem at HMRC. So when you're a startup, you have finite, but you're trying to do a lot of different things. You're trying to create a new product, you're trying to raise capital, then you have to try and figure out how to sell it. You've limited resources. So the first thing I'd say is you have to bring in an advisor. Do not, under any circumstances, try and do this yourself. It would be, it's too involved, it's too complex, and you've got too much other things to be doing if you're running a proper innovative startup. In hindsight, of course, this wasn't worth it. I mean, this has taken years, and it was painful, and you know, I'll never get those hours back and that time back, and so it wasn't there. But I'm by nature a techno optimist, so you kind of have to hope that this will change some behavior, and I think without an R&D tax credit system and also the EIS scheme for to help you raise capital, there will be no startup ecosystem in the UK. Like, I honestly believe if you got rid of those two schemes, everybody with ambition should just get on a plane and leave the UK. Like that's how bad it is, because it's not easy to raise capital here. It's not easy to build startups here. It's probably not easy anywhere, but it's not going to happen. Like, innovation and the growth that can come from innovation will not happen in the UK without these schemes. So I think big picture, I have to be optimistic and say, look, hopefully this doesn't happen to people going forward. It is a great scheme if it was implemented properly. It's a generous scheme, and we should recognize that. But at the same time, without that scheme, I think there'll be very little innovation in the UK, and the UK needs it, because ultimately we need growth. So I would say to startups, yes, make the claim, yes, use an advisor, and I would hope that HMRC will be cognizant of this judgment and change some of the behaviours. And that isn't to say allow fraudulent claims. They should all be stopped immediately, because they hurt both the startups and the tax, but they hurt everybody. So nobody wants fraudulent claims. But, you know, yeah, I hope for change. And of course, yeah, it's a great scheme and people should avail of it.
Barrie, same question to you.
I think I agree. It's a very generous scheme. I know recently it's been merged, or it's been merged, but not quite taking effect at the moment. I think this is an entitlement. This is what this government has and wants to promote innovation in the UK. Okay, the way that they are policing is just not fit for purpose. It's just not fit for purpose, and therefore it is putting people off. It is putting people off. They within and Asian Revenue and Customs have had a lot of some really bad what are called actors coming up from the R&D tax consultants are out there who are just playing a numbers game. And yes, they're being caught out now. They are being caught out now. But if you're contacted by somebody who is a cold sales led and they're trying to rush you, you don't know who they are. They're not somebody that's been referred to you and they're giving you kind of sometimes some false promises as well. I mean, I've been doing this for, oh my gosh, just about 23 years. I set up Myriad 10, 11 years ago, and we focus on software development claims, and we don't actually have a cold call sales team. We don't do that. We just provide advice, and we advice, and we will assess. We actually do a great job for HM Revenue and Customs here. I'd probably say, in a week out of 10 calls, we're probably only 2 that we would actually say you've got genuine R&D here. We're sifting out a huge amount for HM Revenue and Customs. I think they need to, one, acknowledge that. They need to sort out the advisors that have come in, which they have allowed, the cowboys. I'm not here to mention any names, but just be careful who you're dealing with. Absolutely be careful who you're dealing with. I mean, if you know of a friend that's making claims and you know that R&D advisor, he has got competent professionals within your domain, so you can have a discussion with them. They understand what you're talking about. They understand what the baseline position is, which is what we have. They're the people you should be using. Absolutely should be using. And there are others out there, apart from us as well. Once again, I'm not going to go into names, but I would say there's probably half a dozen R&D tax advisors have been there for a number of years, and they have a great reputation, and they probably take away 80% of the spurious claims or claims that would not reach for HMRC and Customs. I mean, I think that's where people need to focus. Work with an advisor that you trust, that's got competent professionals. Nothing wrong in saying, I want a R&D tax claim, but can I speak to, somebody who'll be looking after my tech narrative? Have a chat with them. That's what you need to do.
Yeah, there's three things I'd like to add to that. One is, big shout out to Lauren, and I know Barry's on the call, but actually there was a team. It wasn't just Barry and I. The two of us were at, sitting. Two of us were sitting at the tribunal, but there was a team effort, and there was a lot of work went in, particularly when we got the initial check on our claim, right? There was a lot of work that was done by the team, and two, there was, I don't really know about the bad advisors, but I think some people might think they can do this themselves, and really it wouldn't have been possible to get where we got to without working with an advisor, and actually it would have been worse, because the caseworker threatened to fine me effectively, and the only reason he couldn't really push that one through, which he would have, I believe, was because there was an advisor involved, because it showed, well, wait a minute, I didn't just invent this claim. So I think that's another reason for using an advisor on this.
So yeah, look, we've only got a couple of minutes left, so I'll just sort of open the floor to you guys and just allow you, I suppose in a couple of minutes, basically, just to, I suppose we've covered what changes or improvements you'd like to see, but if there's anything else, basically, that you want to talk about, maybe how HMRC can support innovative companies better, how they can support claims better, obviously we've covered that, but just anything else, maybe you want to address companies who are unsure, anything else you guys want to cover off, feel free to do so.
Yeah, I think this is what we're talking about a lot about here, the inquiry process. And I also think, though, that there are some companies here that are probably about to start their journey within the R&D tax claim world. As I've said, this is an entitlement. And one of the things that you can do when you speak to an advisor that's got the competent professionals, you can pick up the phone, you can have a chat with them. There's no commitment on that part. We certainly provide that. We have this, whether it's that you pick up the phone, or if you want to go on our R&D tax claim portal, which is TaxCloud, you can put your information in there, and we will have a discussion with you. We will review that, and we will give you, confidence whether you have a legitimate claim or not. That's the starting point. So I would start with that. As I said, this is an entitlement. This is an incentive that's been given by the government, and started off, I think it was Labour, then it was Conservative, and now it's back to Labour. But they're there to support, and I think you should try and also put to one side how it's managed at this moment, because it's not very well, it's pretty poor from each and every customer's point of view, and you can't speak to people and that kind of stuff. It's ridiculous, but do not be put off. I think it's important. I take Edward's point on this as well. If we don't push back and we don't keep the claims coming, this is going to starve innovation within the UK. Not just for software development. That's an extremely important area for the UK if they particularly want to become world leaders. But other areas as well. As I said, we've got another tribunal case going in, and that's to do with pharmaceutical, and it's actually got a professor behind it as well. He's part of the board. He's director of the business, and that one's going through and or starting its journey at the tribunal. It's peanuts in terms of value. And we've got the same kind of response that we're getting that we got from Get On Board. As I said, it's slam dunk. It is absolutely innovation. Innovation at its core. They've even got a patent they've just applied for. It's absolutely ridiculous. So have the confidence, put the claim in. That's what I would say. Just have that confidence. Speak to a trusted advisor. And if they're a trusted advisor, they will say absolutely no if you've not got a claim. As I said, we reject 80% of the inquiries that come in because it just does not stack up.
Yeah, Edward, anything from you to finish off?
No, I mean, look, through the whole process, as Barrie said, we were frustrated by an inability to speak to somebody at HMRC. If there was one thing I could wish for, which probably won't happen, but I'll express my wish, it is that somebody at senior at HMRC calls Barrie and myself and says, look, they can do it off the record. We recognize something went wrong here. What do you guys think we should change? How can we improve this? How can we do better? I have views on how to stop the fraud, not just how to allow stuff through, but how to create cheaper, more efficient filters and how to run this process in a better way. Because this costs HMRC a lot of money, right? They had cancelled that tribunal. They had to spend time writing letters back to us. It's not a zero cost thing for them to even refuse these claims. So when they're refusing, they should be doing it based on, yeah, this is an absolute refusal. And when we go to tribunal, we will absolutely win. So that would be my wish, that somebody at HMRC actually takes this seriously and actually goes, guys, we got it wrong. How do we make sure this doesn't happen again? That I'm sure it won't happen, but that's what I wish for.
Absolutely, Edward. That would be a great wish. And I would also bring somebody from the innovation, representing the government here, maybe one of the ministers, because there's this huge disconnect between what the government are promoting, which is absolutely solid, and is required. Some areas maybe not quite the way it needs to be, but artificial intelligence, absolutely. And I do feel that there's a complete disconnect here, and I think they need to breathe. You've almost got one that's promoting, you've almost got one that's suppressing the innovation, and it's completely not joined up. So I would, bring in one of the government ministers as well, that heads up the innovation department within customs.
No,
with the Labour, bring them together because they need to realise what impact this is having on SMEs, high-tech startups. I mean, it's huge. It's absolutely huge. And I agree, Edward, if they carry on in this way, and I've heard it already from a number of startups who are coming to say, where do I go? Do I invest in the UK? Do I invest in Ireland? If I'm giving honest advice at this moment, it wouldn't be the UK. It wouldn't be the UK.
No. Which is a shame. As you said, the noises from the government and policymakers are the right noises. I think they understand where it's meant to be going. But if you are totally honest, it felt like the caseworker believed his job was to say no. He really thought, I don't think he thought I'm being a bad person or it felt like to me, he felt like I'm completely justified. My job is to say no to as many things as possible. And I can see an angle for saying no here, so I'm going to say no. And that isn't consistent with the policy directive.
And that feel is just not with Get On Board as well, and the tech that you've developed there. This is going. We have this. I mean, with other companies come to us to say, "Can you help us with the tax inquiry?" And once again, we do a quick review, and some of them are like, you got, you actually, whoever's come up with your claim, it's just a complete, you've got no chance. Just, stop it immediately. Try and protect yourself from a penalty position. But there are people that have got highly innovative. I mean, this isn't borderline cases where you've got an inspector who's just gone back, exists. Yes, the product may exist somewhere else or something very, very similar, but you don't actually understand what's behind that product, what the actual innovation is. You just do not understand. We're not talking about the application or the product. We're talking about the technology within that, the layers that you're developing, the machine learning engine, etc., all the rest of it. And no, I would welcome a discussion with somebody high up in the HMRC Customs R&D team, but also with input. Just join this together. Let's just join it up and work together, because that's what we're here for. We're here to support and make the whole process for reviewing claims, as trouble-free as possible for HMRC Customs.
Okay, well, thanks very much, Edward and Barrie, for joining us. Yeah, it's been a great call. Thanks very much for your input on the case, both of you. And yeah, hopefully everyone enjoys listening and watching.
Cool. Bye.
You're well. Thank you.